We're having another necessary conversation about the experiences of thousands of disabled children and young people. We'll be discussing the systemic barriers they experience when trying to access and remain in mainstream education. To help us, we've been speaking with solicitors to answer some of the legal questions around these barriers. We're doing it from an inclusive education perspective. And joining us is Richard Nettleton from SEN Legal. He will answer our questions about the legal options available when advocating for mainstream education.
I'm Richard Nettleton, Solicitor and Director at SEN Legal. The information provided in this Q&A is for general informational purposes only and does not constitute legal advice. If you require legal assistance or advice, I strongly recommend consulting a qualified legal professional who can provide you advice based on your specific situation.
Could you please explain what presumption to mainstream education under the Children and Families Act 2014, C&F Act 2014, means in practice for disabled children and young people?
The Children and Families Act 2014 was enacted by the Cameron government with the aim of reforming services for disabled children, young people and their families, particularly those with special educational needs and disabilities, or SEND. In respect to the presumption to mainstream education, this is covered by sections 33, 34 and 39 of that Act. Section 33 means disabled children with an EHC plan should be educated in mainstream schools unless this would negatively impact the education of other students and no reasonable steps can be taken to prevent the incompatibility. Section 39 provides that a placement of parental preference must be named unless the local authority deems it to be unsuitable or incompatible. Put simply, unsuitable is in respect of age, aptitude, and being able to meet the special educational needs. Incompatibility, on the other hand, is about the efficient education of others and efficient use of resources. Jumping back to section 34, this is for anyone without an EHC plan, with the automatic assumption being that they will attend a mainstream school. However, they will only have access to ordinarily available provision and reasonable adjustments in respect of meeting their needs.
How can a parent of a disabled child use the C&F Act 2014 to support their child's right to an inclusive education?
If a parent is seeking a particular school to be named in the EHC plan, providing they're a qualifying school under Section 38, for example, a maintained school or an academy, then they will be consulted by the local authority. In the consultation response, that school must show that it has not just met the test in Section 33 of the Children and Families Act 2014, but also Section 39. While each case is specific to the disabled child, should the parent believe the response is insufficient and the local authority does not name their preferred school, they can make an appeal to the SEND tribunal when a final EHC plan is issued.
What constitutes reasonable adjustments under the Equality Act? And what action can parents of disabled children take if a school fails to comply with this duty for their child?
There is no strict definition for this, with the word reasonable meaning different things to different people. Reasonable adjustments are changes made to remove or reduce disadvantages faced by disabled pupils in schools, ensuring they have equal access to education and activities. For example, movement breaks, flexibility on uniforms. If the school does not implement reasonable adjustments, then the parent potentially has a case which can be brought to the SEND tribunal for disability discrimination. However, it should be noted that the tribunal's power is limited in respect of remedies to resolve the issue, for example, an apology or complete some training.
Are there any precedents or successful cases that you can share that have supported the placement of disabled children and young people in mainstream school or college?
Unfortunately, not in recent years, as the SEND tribunal does not publish cases unlike other tribunals, which was due to a growing demand. However, it should be noted that parents for the last 2 decades have seen a 90% plus success rates when bringing cases of all types to the tribunal.
What is the role of tribunals in cases where disabled students are denied their statutory right to mainstream school and college?
This very much depends on what type of claim is brought. The tribunal's role is to either make a decision in respect to the placement that the disabled child will have named in their EHC plan and therefore attend going forward, or make a decision about whether discrimination has occurred.
What is the process for parents of a disabled child to bring their child's case to the Special Educational Needs and Disability (SEND) tribunal, and what are the key timelines they should be aware of?
In respect of an appeal to the SENT tribunal over the contents of an EHC plan and the school that has been named, the deadline for appealing is 2 months from the date of the decision letter issued by the local authority, which provides you a final EHC plan. In respect of a disability discrimination claim, this deadline is 6 months from the date of the discriminatory incident.